There are cases that stay with you, not because they were the loudest or the most complicated or the ones that made the headlines for weeks, but because of one moment. One quiet, impossible moment where everything that seemed wrong suddenly became right again, where a system that felt cold and indifferent showed that it still had a heartbeat. I've been following courtroom stories for a long time, and in all of that time, I have never seen a letter change a room the way this one did. This is the story of Margaret Elaine Hartwell, a woman who lost her husband, then nearly lost her home, and then found herself standing in front of a judge who had every legal reason to rule against her, but who chose to pick up a single sheet of paper first. By the time this is over, you'll understand exactly why that letter mattered. And I promise you, the answer is not what you think. Margaret was 63 years old when her husband, Robert, died of a sudden cardiac event on a Tuesday morning in March. He was in the kitchen. He had just made coffee. She found him on the floor. They had been married for 38 years. Robert Hartwell was a retired postal worker, steady, quiet, devoted. The kind of man who fixed things around the house without being asked, who remembered anniversaries, who drove Margaret to her sister's house every Thanksgiving, even though he didn't particularly get along with her sister. He wasn't a remarkable man by any conventional measure, but he was remarkable to her, and in the way that quiet, loyal people are, he was the load-bearing wall of their entire life together. When he died, Margaret didn't just lose her husband. She lost the person who managed everything: the mortgage, the bills, the insurance forms, the lease renewal on the garage. Robert had taken care of all of it for decades, not because Margaret couldn't, but because that was how they had divided things. She ran the household. She cooked, she cleaned, she raised their 2 children, she handled the groceries and the doctors and the school schedules. He handled the paperwork and the finances. It was an arrangement that worked perfectly for 38 years. And then, without any warning, it stopped working, because he was gone. The home they lived in was not owned outright. Robert had taken out a reverse mortgage on the property several years earlier to help cover medical costs after a surgery. It was a complicated arrangement, and not one that Margaret had fully understood at the time. Robert had explained the basics, that they could stay in the home as long as one of them lived there, that the loan would be repaid when the home was eventually sold, but the finer details had never been her territory. What she did not know, and what Robert may not have fully understood either, was that upon his death, the loan would enter a default period. That within a certain number of months, she would be required to either repay the loan, refinance the property, or vacate. The lender was a company called Vantage Horizon Financial, and Vantage Horizon Financial moved fast. Within 6 weeks of Robert's death, Margaret received the first letter. It was written in dense legal language, full of terms like maturity event, and due and payable, and foreclosure proceedings. She read it 3 times and understood almost none of it. She called the number at the bottom of the letter and was placed on hold for 45 minutes before speaking to a representative who told her, in a tone that Margaret would later describe as very polite and completely unhelpful, that the balance of the loan was due, that she had options, and that she should consult an attorney. She did not have the money to consult an attorney. She did not have the money to repay the loan, and she did not have anywhere else to go. Here is what you need to understand about Vantage Horizon Financial. They were not, on paper, doing anything illegal. Reverse mortgage law is complicated, and the terms of Robert's agreement, while harsh in practice, were technically disclosed and technically signed. The company operated within a gray space that is, unfortunately, not uncommon in the financial services industry. They bought distressed loan portfolios. They aggressively pursued repayment timelines. They had a legal team, a collections team, and a process that ran like a machine. What they did not have, apparently, was any instruction to treat the human beings on the other end of their paperwork as human beings. The representative Margaret spoke to was a man named Derek Albanese. He handled her case from the beginning. And from all accounts, from Margaret's own recollections, from the case record, from emails that would later be submitted into evidence, Derek Albanese was efficient, technically compliant, and utterly without empathy. When Margaret called to explain that her husband had just died, that she was still in the middle of making funeral arrangements, that she didn't fully understand the letter she had received, that she had been married to this man for 38 years, and she was 63 years old, and she needed more time. He told her the timeline was set by the terms of the loan. When she called again, 6 weeks later, to say that she was trying to find a housing counselor, that she had reached out to 2 attorneys who couldn't take her case, that she was doing her best, he told her that the clock was still running. When her daughter called on her behalf, crying on the phone, explaining that her mother was still in grief, still barely sleeping, still figuring out how to pay basic bills without her husband's pension, Derek Albanese told her that Vantage Horizon Financial sympathized with the family situation, but that the company's legal obligations required them to proceed. He used the phrase, "proceed accordingly," 11 times across documented communications. Not once did he ask how Margaret was doing. The foreclosure notice arrived on a Thursday in October. Margaret had 7 months. She spent those 7 months doing everything she could. She reached out to a local nonprofit housing organization that helped her understand the terms of the loan for the first time. She contacted her congressman's office. She applied for hardship assistance through 2 different state agencies. She wrote letters, handwritten letters on paper, because that was what she knew how to do, to Vantage Horizon Financial's customer service department, to their corporate office, and eventually to the CEO himself. She received one response. It was a form letter. By the time the case reached the courts, Margaret Hartwell had exhausted nearly every avenue available to her. She was represented, at no cost, by a legal aid attorney named Sandra Okafor, who was 31 years old, 2 years out of law school, and working out of a small office above a dry cleaning shop on the east side of the city. Sandra was good. She was sharp and thorough, and she believed in the case, but she also knew what they were up against. Vantage Horizon Financial had a senior attorney, a man named Franklin Kress, who had been practicing law for over 20 years and who had handled dozens of cases like this one. He walked into the courtroom on the morning of the hearing, wearing a suit that cost more than Sandra's monthly rent. The judge assigned to the case was the Honorable Arthur Beaumont, 61 years old. Former prosecutor, 22 years on the bench, known in the legal community for being calm, methodical, and exactly no one's fool. He entered the courtroom at 9:07 in the morning, took his seat, looked at the case file in front of him, and asked both parties to state their positions. Franklin Kress went first. He was composed, practiced, and precise. He laid out the terms of the reverse mortgage agreement. He cited the relevant statutes. He noted that Vantage Horizon Financial had provided proper notice at every required interval, had followed all required procedures, and had, in fact, extended the timeline voluntarily by 30 days as a good faith gesture. He said the words, good faith, with the kind of confidence that comes from believing your own framing. He then summarized, calmly and thoroughly, that the law was on his client's side, that there was no legal basis for the court to prevent the foreclosure from proceeding, that Margaret Hartwell, while clearly a sympathetic figure, had no legal claim to remain in the property beyond the terms of the agreement. He was not wrong about any of it. Sandra Okafor argued her case with everything she had. She raised questions about the original loan disclosure. She argued that Margaret had not been given adequate information at the time of the loan's origination. She submitted documentation showing the timeline of communication and the inadequacy of the responses Margaret had received. She argued for a continuance. She asked the court to consider the hardship involved. Franklin Kress responded to each point efficiently and without visible concern. Judge Beaumont listened to all of it. He asked several questions. He was quiet for a long moment after both sides finished. Then he said, I've been given a letter to read before I issue a ruling. I'm going to take a few minutes. The room went still. Sandra Okafor didn't know what letter the judge was referring to. She looked at her client. Margaret looked back at her. Franklin Kress looked mildly annoyed. He checked his watch. The letter had been submitted to the court 3 days earlier through a procedural channel that Sandra had almost not pursued. She had been reaching for anything she could find, any additional documentation that might humanize her client's case. And a colleague at the nonprofit housing organization, a woman who had worked with Margaret for 4 months, had suggested she submit a piece of correspondence that Margaret had held on to. It was a letter that Robert Hartwell had written to his wife. Not a legal document, not an affidavit, not a financial statement. A letter, handwritten, 4 pages. Written on the night before, he was scheduled to go in for a medical procedure 2 years before his death. A procedure that had carried some risk, and that had, clearly, prompted him to put some things on paper. Judge Arthur Beaumont read it quietly. The courtroom was silent enough that you could hear the air conditioning. He read all 4 pages. No one in the room knew exactly what was in the letter. Not Sandra, not Franklin Kress, not the court reporter, not the bailiff. Only Margaret knew what was in it. And she was sitting with her hands folded in her lap, looking at the table in front of her, not at the judge. When Beaumont finished, he set the letter down carefully. He looked up. He removed his glasses and set them on top of the letter. He looked at Franklin Kress first, then at Sandra Okafor, then at Margaret. He said, "I want to address something before I discuss the legal merits of this case." He paused. "In 22 years on this bench, I have read a great many documents. Legal briefs, expert reports, financial statements, affidavits. But I want you to know that what I just read was written by a man who knew exactly what he was doing when he sat down to write it. He wrote it for a specific reason. And I think everyone in this room deserves to understand what that reason was." He picked the letter back up. He read a portion of it aloud. Robert Hartwell had written, among other things, the following: that he was afraid, not of the procedure, but of what might happen to Margaret if something went wrong. That he knew she had never handled the finances. That he knew the mortgage situation was complicated. That he had tried, the week before, to sit down with her and explain it, and that she had said, "You'll be fine, Robert, don't be morbid," and changed the subject because she couldn't bear to hear it. He wrote that he was sorry he hadn't done a better job of making sure she understood. That it was his fault, not hers. That he had always meant to fix it, and had kept putting it off, because neither of them wanted to think about the day when fixing it would matter. He wrote that if she was reading this letter, something had gone wrong, and that if something had gone wrong, he needed her to know one thing above all else. He wrote, "You are not helpless. You only think you are. 38 years ago, I watched you raise 2 children and run a household, and take care of everyone around you without once stopping to ask for credit. You are the strongest person I have ever known. I am sorry I never said that clearly enough while I was alive to say it." And then, on the final page, he had written, "The house is yours, Maggie. I know it's complicated, but it's yours. We built it together. Please fight for it. Don't let anyone tell you that you don't deserve to stay in the place where we lived our whole life." Judge Beaumont set the letter down again. The room was completely silent. Margaret was crying. She had not made a sound. The tears were simply running down her face, and she was still sitting with her hands folded in her lap, and she was not moving. Franklin Kress had stopped checking his watch. Sandra Okafor was staring at the judge with an expression that was equal parts grief and something close to hope. Judge Beaumont said, "I am not going to pretend that this letter changes the law. It doesn't. Mr. Kress is correct that the terms of this loan are legally enforceable. He is correct that his client followed the required procedures. He is correct that there is no strictly legal mechanism that automatically prevents this foreclosure." He paused. He put his glasses back on. But I am also a judge in a court that has equitable jurisdiction, and I am going to use it. He looked directly at Franklin Kress. I am ordering a 90-day continuance. During that time, I am ordering your client, Vantage Horizon Financial, to engage in good faith mediation with Mrs. Hartwell and her counsel. Not the kind of good faith that means sending a form letter. The kind that means sitting down in a room with a human being and trying to find a solution that doesn't require a 63-year-old widow to lose the home she has lived in for decades. He then said something that would be quoted in the local paper the following week. He said, "I have been on this bench for 22 years. I have watched this legal system do a great many things that are technically correct and morally indefensible. I am not going to add this case to that list. Not today." The 90-day mediation did not go smoothly. It never does. Vantage Horizon Financial initially sent a mid-level representative who had no authority to make any actual decisions. Sandra Okafor objected. The judge was informed. A second session was scheduled. This time, someone with decision-making authority was present. Over the course of 6 weeks, something shifted. It was not a dramatic shift. It was not the kind of thing that makes for a neat story. But somewhere in the process of sitting across a table from Sandra Okafor and looking at the documentation and having to respond to questions from a mediator who had read the 4-page letter, the representative from Vantage Horizon Financial began to understand that this case was not like the others. Not because of the law, because of the letter. Because Robert Hartwell had written 4 pages by hand on the night before his medical procedure, and his wife had kept those pages for 2 years without knowing they would end up in a courtroom, and a judge had read them aloud in the quiet of a morning hearing, and the words had landed in the room in a way that could not be undone. The final agreement allowed Margaret Hartwell to remain in the property under a restructured arrangement that significantly reduced the monthly obligation. It was not perfect. Nothing is. But it kept her in her home, in the home where she had raised her children, in the kitchen where Robert had made his last cup of coffee. I want to be careful here, because it would be easy to take this story and make it into something simple, into a lesson about one good judge, or one letter, or one moment of grace in a system that otherwise grinds forward without looking up. But I think the deeper truth of this story is more uncomfortable than that. Vantage Horizon Financial was not, in any technical sense, wrong. They had a legal right to pursue that foreclosure. Derek Albanese, for all his coldness, was doing what he was trained to do. And the system that allowed this situation to develop, reverse mortgages that widows don't fully understand, timelines that don't account for grief, a legal framework that processes people the way it processes paperwork, that system is still there. It did not change because one judge read one letter. What changed was one case. For one woman, because of one letter that her husband wrote on a night when he was afraid and honest and running out of time. There is a question I keep coming back to when I think about this story. Why did Robert write it? He could have spent that night the way a lot of people do before a medical procedure, distracted, watching television, telling himself it would all be fine. He could have put off the difficult conversation the way they had always put it off, the way most of us put off the conversations that feel too heavy to start. Instead, he sat down and wrote 4 pages. Not because he thought anyone besides Margaret would ever read them. Not because he knew there would be a hearing, or a judge, or a courtroom that needed a letter. He wrote them because he loved her, and he was afraid, and he had something to say that he had been waiting too long to say. He wrote, "You are the strongest person I have ever known. I am sorry I never said that clearly enough while I was alive to say it." He said it clearly enough. It just took a judge reading it aloud in a quiet courtroom on a Thursday morning in October for the words to reach the people who needed to hear them. Margaret Hartwell still lives in her home. She has a photograph of Robert on the kitchen counter next to the coffee maker. She told the housing counselor who had worked with her, after everything was resolved, that she talks to the photograph in the mornings, that she tells him what's happening, that she told him, the day the agreement was signed, that she fought for it, just like he asked her to. He would have been embarrassed, she said. He wasn't a man who liked being talked about, but I think he also would have been glad that someone read his letter, that it mattered. There are moments in this world when everything that is supposed to be cold and mechanical and procedural pauses for just long enough to let something human through. This was one of those moments. Not because the system bent, not because the rules changed, but because a man who loved his wife sat down one night and told the truth about her, about who she was, about what she deserved, about the home they had built together and the life they had shared in it. And his words were still there, on paper, 2 years later, waiting. Sometimes the most powerful thing a person can do is write something honest and leave it where it can be found. Robert Hartwell did that. And because he did, his wife is still home.